This account was created to provide information on how current immigration laws apply to certain factual scenarios. There are many, I suspect, who are worried about their immigration situation, but they're not sure if they should speak to an immigration attorney. Keep in mind, and I cannot stress this enough, that immigration law is unbelievably fact-specific. So even if you think that your situation is nearly identical to one of the ones that I go over here, you still need to speak to an immigration attorney personally. Even the smallest factual changes can make a big difference in the outcome. That said, this is not legal advice. I'm hoping this will merely help educate people as to how the immigration laws work, because I know there are a lot of anxiety exists in certain immigrant communities. Also, immigration laws and procedures will likely change quite a bit in the months to come. So what might be accurate and current at the time of this recording very well could change in the weeks to come, maybe even tomorrow. So this man, Mario, had a petition filed for him on April 30th, 2001 by his permanent resident father. At the time of the filing, Mario was under 21 years old and was not married, even though he was with his partner, Yolanda. Mario and Yolanda are still together, and they have 3 children, 21, 17, and 12. They have never married because they were told that if Mario marries, his petition from his father would essentially become void and would no longer help him get a green card. Mario's father is still a permanent resident and has not become a U.S. citizen. The couple wants to know what they can do to legalize their status. All right, so this one gets a little complicated. Mario has a filing from the father, and the father's a permanent resident. Now, he wasn't married to Yolanda at the time that it was filed, so she's not protected by 245I. Even if their 21-year-old child wanted to petition for both of them, it's still not going to benefit Yolanda, assuming that she entered illegally, because she wasn't married to Mario, so she doesn't have that protection. Now, what if Mario and Yolanda get married right now? Well, if they get married right now, then the petition that Mario's father filed for him becomes void. And the reason is there's a visa classification for unmarried adult children of permanent residents. However, there is no visa classification for adult children who are married. Okay, so adult children of permanent residents who are married, there is no classification for that. So the minute that he gets married to Yolanda, that petition that was filed for him by the father has no value anymore, okay? The one thing that we could do is that the father could apply for naturalization, become a citizen, okay? And then we could file, and then Yolanda and Mario could get married, and then we could file for both of them, all right? And the reason is, if we do it in that order, that as soon as the father becomes a U.S. citizen, they change their classification. Mario changes his classification to an adult child of a U.S. citizen, all right? Then once he gets married to Yolanda, now he's a married adult child of a U.S. citizen. But there are classifications for each one of those, so at no point does the petition become void, all right? So this is a very complex scenario, but there is a path to getting both Mario and Yolanda green cards, okay, through the father's filing. Now, if the 21-year-old wants to file for Mario, that's not really going to solve too many problems here. It's not going to include Yolanda in the green card process. So, if for some reason the adult father doesn't want to become a U.S. citizen, then the only strategy we have is to get Mario his green card. Once he has his green card, now we can go through the 601A waiver process, and we can process Yolanda's case in Ciudad Juarez, assuming she's from Mexico, which it doesn't say that she is, but if she is, then that's where we would process her case. The downside of that is that doing a 601A case is probably going to take 4 years, possibly 5 years to complete these days. So that's a very long time to wait. So if this were my case, the next step I would take is talk to the father, see if he's willing to naturalize, see why he hasn't done that yet. Is there something, does he have a criminal record? Is he concerned because the way he got his green card initially wasn't legal, possibly, or there's concerns about that? I'd want to know why he hasn't naturalized yet, and then we can advise on, how we're going to move forward with this. Again, if this scenario sounds like anything you're dealing with, feel free to reach out to us. We can set a consultation and figure out how we can help, if we can help, and how long it'll take, and all those types of things. So good luck, everyone, and continue to stay informed.